Good afternoon. Please be seated. We have two cases on this afternoon's docket. I will go ahead and take announcements from both of them at this time. The first one is the State of Texas versus Stubbs.
Jessica Akins for the State of Texas.
Mark Bennett and Mike Russo for Abigail Stubbs. Mr. Russo will be at the table with me with my argument.
All right. Would the state like to reserve time for rebuttal?
Yes, Your Honor. 5 minutes, please.
Thank you. The other case is Gillen versus U.S. Bank.
Jeffrey Jackson for the appellant, Ruth Ian.
Mark Rutherford for the appellate.
All right. And would the appellants like to reserve time for rebuttal?
The appellant would like to reserve 3 minutes for rebuttal, Your Honor.
Thank you. All right. Stubbs case, whenever you're ready.
Good afternoon. May it please the court. I'm Jessica Akins. I'm representing the state in this case. And I realize what we're asking you to do is something that's rare. It's not something that we do that often, but it's something that we do when we feel like a trial court has not followed the law. And in this case, as you know, the defendant was charged with online impersonation, and they filed a writ of habeas corpus to dismiss that indictment on 3 constitutional bases, there being an overbroad vagueness and a violation of the Dormant Commerce Clause. I realize we're a little short on time today. I feel like we've sufficiently briefed these issues, and I'm hoping maybe we're not here today to talk about the Dormant Commerce Clause. If we are, we can get to that. I think the overbroad issue is the big issue that we see.
At the outset, let me ask if you think that yesterday's ruling by the Court of Criminal Appeals in Ex parte Perry has anything to do with what can be raised in a pretrial writ of habeas corpus attacking constitutionality.
I think in that specific case, it did change the law in terms of an as-applied challenge being brought pretrial. I don't think it has any bearing on a case like this. And first of because I think it's restricted to the exception they made for a public official. The whole reason that they let him bring an as-applied challenge pre-trial was that he needed to have an answer to do his job. The examples that the opinion gave were all examples that trial courts, legislators, government officials like a governor would need to act on to do their job, and it would inhibit them
and that
to wait.
doesn't have some type of equal protection implications down the road? I mean,
It's possible, but that statute is specifically for official oppression used by public officials. That's not a statute that would affect a normal person like in this case, and I can't see any difference in bringing as applied versus a facial challenge on a regular citizen coming under this statute versus one that is restricted to government officials.
Okay.
And with that, I will say we are bringing a facial challenge today, not an as-applied challenge. And in that, we do have differing opinions on the standard of review. And I think it's important to possibly look at that before we get to the overbreadth challenge, because there are differences in terms of the burden and what each party has to show. As you know, the defense is arguing this is content-based and that it's going to be lumped in with all the other opinions from the Court of Criminal Appeals, which include Thompson and Lowe, and now the newer case, Johnson, with the flag burning. Those are about speech rights, obviously, and there's a little gray area in terms of expression. And I think the defendant is trying to parlay what they perceive, free speech, into an expression on the internet, and then also say that that would be covered under the First Amendment. Our position is there's a wealth of case law, federal case law, U.S. Supreme Court, and from the state of Texas that shows that when you use a statement that might be initially protected, you use that statement to further your criminal offense, you've just left the protection of the First Amendment, and you're now in the realm of the Penal Code. And that's why the state feels the other standard, the intermediate standard of review, is correct in this case. We're talking about conduct, talking about placing someone's information online, pretending to be them, and also having a malicious intent, as the statute lays out.
Let me ask you this. When you say that you have left free speech and gone into the Penal Code, is that are you saying that's because of the verb use?
Yes, it's not just holding a belief. It's once you start to do something with that belief that changes the intent. There's a great example in Ex parte Lowe that Judge Johnson gives. She talks about armchair thoughts. If you're sitting in your armchair, you can think anything you want. You can think about murdering someone. You can think about weird sexual thoughts. All of that belongs to you. The moment you get out of that armchair, you go do something with those thoughts that turns it into criminal activity, you've left, and now you're in the Penal Code. You're outside of the First Amendment.
That includes just writing them down?
Maybe not writing them down. In this case, I don't think it's just writing them down. It's the possessory of being this person. I'm maliciously taking on your identity to say something else. We're not talking about just a blog that criticizes someone. That's completely legal. That's a First Amendment protection. We have no problem with that. But that's not really the conduct that this statute entertains. This is about impersonating someone, pretending to be them, and then putting something out there false to hurt them. It's quite different than just having a blog or an opinion about, I don't like this political leader, I don't like this religious leader. And there's good federal case law on that. In fact, one good case is the Cassidy case, U.S. v. Cassidy, where a defendant brought a challenge. He was charged with writing an anonymous blog criticizing a religious leader that was very unpopular. And he went all through the courts in a cyber stalking case, and they actually found his case was unconstitutional as applied to him, but they didn't strike down the statute. Just because there might be a little bit of area where someone can be charged with this crime doesn't mean it's facially unconstitutional. What it means is that defendant has a right to bring either a sufficiency claim or an as-applied factual challenge after those things have been fleshed out through a trial in the appellate process.
If the state is successful in this case, could Ms. Stubbs later make an as-applied challenge?
Sure.
Could she also use the Perry case to
She could try. I don't feel like she'd be successful. I think she could try, and that would be something for the courts to find how far the Perry case is going to go in terms of as applied. But I think if you read the language, especially the concurrences, I mean, there's 2 concurring opinions, 2 dissenting opinions. You've only got 8 judges hearing the case. Burt Richardson was not on that case. There's a lot of opinions in there, and I think with Court of Criminal Appeals, you learn a lot from concurring opinions. You know when something else comes down the pipeline, what they're going to feel. And when you read those concurrences, they are saying this is rare, this is particular, this is to this type of offense in this particular case. It's not going to be generally broadly applied, and I think they made that very clear. With regard to the statute that they claim, in this case, that it's overbroad, if you look at the appellant's briefings, they're sort of conceding that some of the things actually are constitutional. There's 4 ways you get there on the overbroad. It's defraud, threaten, harm, and intimidate. And they've pretty much said that they agree the intent to defraud and the intent to threaten is not protected by the First Amendment. So clearly we're not even talking about those. That leaves us with harm and intimidate. Intimidate is interesting because if you go back and read Thompson, Thompson is the case that struck down the improper photography statute. In Thompson, while they're talking about that statute, they make a comparison to the types of things that they would say were not protected by the First Amendment. And what they say, the Court of Criminal Appeals in Thompson says, the intent to threaten and the intent to intimidate are not protected by the First Amendment. So even though we don't have this particular statute, any case law on it, we sure do have some guidance from the Court of Criminal Appeals on how they're going to look at that term in this statute.
In your briefing, you didn't particularly construe the statute or give definitions of some of the words in the statute. Does that mean that you agree with the ones put forward by the applicant?
I think what I did was I defined harm, which I think is the most problematic for us as the state, and I gave you the definition of harm that includes injury, and there's plenty of federal case law that says any type of injury to a person is outside the scope of the First Amendment. And the rest of the terms, I think what I had put is that you use the ordinary meaning. And we do that a lot even with jury charges. We don't have to define every term for a jury, whether it be in the indictment or the charge. They're allowed to use the ordinary, normal meaning of those words if it's not specific. And what's interesting is, back to the harm being injury, there's federal cases, a very interesting case from the New York Supreme Court that says it was very similar in terms of harm to reputation. And in that case, the defendant had put in blogs, emails, pretending to be a bunch of different scholars. And in that case, he made very similar arguments to this case in terms of, if I just put something out there that's insulting or embarrassing to you, that's my opinion. That doesn't hurt you if I'm pretending to be you and I say something bad. And the court said, actually, in this day and age, people value their reputation more than they do any tangible item they own. And when you go after them to harm them or injure that reputation, that isn't protected speech when you're pretending to be them. It's different to criticize someone and make very clear that is not what I'm saying. That is free speech. When you are encompassing someone's identity and putting it out there, it's basically being the source of the information. If you're pretending to be the source of the information and you're pretending to be yourself, or you are yourself, you could say whatever you want. But when you're acting like another person and the source of the information is coming from them, that is fraudulent, that's harmful, and that's injury. And those are the type of cases we're talking about that are being prosecuted under this statute. If you don't have any other questions, I might save my time for rebuttal at this time.
All right. Counsel?
Thank you, Justice Jameson. May it please the court. My name is Mark Bennett. I represent Abigail Stubbs, along with Mark Russo, represent Abigail Stubbs. This is a printing press. It's a mail system. It's a bulletin board. It's the town crier. It is every communications method that the founders could have dreamt of. To say that it's something different than non-internet communication is ahistorical, because this is the equivalent of every form of communication that the founders had in 1791. And I'll get to why 1791 is important in a moment.
Before you get there,
Yes, Your Honor.
Judge McSpadden threw out the entire statute. Ms. Stubbs was only charged under A. Did he have authority to void the entire statute?
No, he did not.
Where does that leave us?
Where that leaves us is probably affirm the voiding of 33.021A, but reverse and order the judge to correct his order so that it only refers to 33.021A.
And in your application, or in the application for writ, did it seek to void the entire statute or just A?
Probably just A,
All right. And,
but I don't have it with me, and
All right.
Mr. Russo doesn't either.
and what is your position with regard to where Ex parte Perry leaves us in terms of procedure?
So the majority opinion opens the door to more as-applied challenges, and I loved Judge Alcala's concurrence to it, because Judge Alcala says, well, you've opened the door, but you haven't explained how widely the door is opened. And what I would say, says Judge Alcala, is that the ability to make the as-applied challenge depends on the right that's being vindicated. It depends on the nature of the right, so that whereas before the court would look at judicial efficiency and whether it would make more sense to raise it on appeal, now, says Judge Alcala, those are no longer elements of the analysis. So on the one hand, I would adopt Judge Alcala's concurrence. On the other hand, I would adopt Judge Newell's concurrence. Judge Newell talked about when the the as-applied unconstitutionality is clear from the pleadings. And the state, in its brief, invoked the sworn complaint in this case, what the police officer said happened. I would contend that that combined with the indictment show that this is a void prosecution as applied. We haven't briefed that, though, and I think that this court can and indeed must void the statute as written. The court must void the statute as written because of U.S. versus Stevens. U.S. versus Stevens said that speech is protected unless it is unprotected, that there are categories of unprotected speech, that these are historical categories of unprotected speech, and unless the statute covers only unprotected speech, it's void. Here we have a statute that
Well,
covers...
the state says that once you insert the verb use, that you've converted it into conduct.
So it's to use a name, and I have a name, it's Mark Bennett. That name is composed of words. When you use words, you speak or you write. It doesn't change speech into conduct. Using somebody's name is speaking that person's name. Your Honor, Justice Jameson, I've just used your name. When I refer to Ms. Akins, I've now used her name as well. Have I done it with her consent? Have I done it without her consent? I've used it. So that if I don't know somebody so that they couldn't possibly consent to my using their name, and I speak ill of them on the internet, I'm using their name without their consent with intent to harm them. And none of that brings this statute under any category of unprotected speech. The state mentioned that in my brief I conceded that threats are unprotected. I'm not sure that I entirely conceded. I may have for the sake of the argument, but Perry brings that into doubt as well, because the Court of Criminal Appeals in Perry adopted a broader definition of threats and then held that the statute under which Governor Perry was charged was overbroad because it adopted the definition of coercion, which adopted the definition of threats, which was itself overbroad. In other words, threats are not unprotected speech. Because if we threaten to harm somebody's reputation, if we threaten to vote against them, if we threaten to veto a bill, these are threats that we're allowed to make. We're allowed to threaten each other. We're allowed constitutionally to harm each other. How might we harm each other? We might embarrass each other. Embarrassing speech is not unprotected speech. We might offend each other. Offensive speech is not unprotected speech. If we're political candidates, and I'm running for the Court of Criminal Appeals, if I say something ill about my opponent, using his name, without his consent, with the intent to deprive him of votes, I am violating the statute because I intend to harm him by depriving him of votes. And if I do it online, I'm violating the statute because I'm using his name without his consent with the intent to harm him in some way. And harm, as defined by the Texas Penal Code, is universal, any disadvantage. And I think the state agrees that embarrassment or reputational harm, that is notoriety, even if the notoriety is truthful, that is, it's not defamatory, you say something bad about somebody, it's truthful.
Well, then why don't your
is
arguments
protected.
feed into the as applied rather than the facial?
Why did I not argue the as applied rather than the facial, or?
No, but it seems that the examples you cite to demonstrate why it's facially invalid would go more to as applied.
Because there are a real and substantial number of them. That's the test for facial invalidity. Are there a real and substantial, is the potential unconstitutional application real and substantial? And the statute is written so broadly that any communication on the internet with the intent to cause anybody any harm, including criticism or political speech, violates the statute. The state argued in its brief that this is not speech. That's ludicrous. Creating a web page is speech. It's the equivalent of writing a newspaper article or writing a letter to the editor or posting something on a bulletin board in the paper and pencil world. If the statute said instead it is a crime to use somebody's name without their consent to post a paper on a bulletin board with the intent to harm them in some way, I suspect that we wouldn't be having this discussion. I suspect that the state is confused because it says internet rather than real world. But posting a piece of paper on a bulletin board or on the internet or anywhere else with the intent to harm them, provided that it's not obscene, it's not soliciting the commission of a crime, it's not child pornography, it's not defamation, is still protected speech. And so the statute does not limit its scope to unprotected speech. Now, the state mentioned Judge Johnson's opinion in Lowe. I don't think there was a Judge Johnson opinion in Lowe. The state mentioned speech incident to criminal conduct. When your speech is part of committing a crime, then it's unprotected. Well, so this is a category of unprotected speech, speech incident to criminal conduct. That's why child pornography is unprotected, because in order to create child pornography, you have to victimize a child. A child has to be victimized, right? So possessing child pornography contributes to the market for child pornography and has people creating more child pornography. And so the Supreme Court has made the judgment in Ferber that this is a category of unprotected speech. In this instance, the state tries to invoke speech incident to criminal conduct, but there's no underlying criminal conduct. The state cannot show you the underlying criminal conduct. Let's use the facts that the state has provided us, because even though the as-written challenge doesn't depend on those, and I contend that it's improper for the state to have included those in the brief in order to influence this court improperly, but let's use them to our advantage, okay? And when we use them to our advantage, we see this woman allegedly received telephone calls. She allegedly received pictures, texts with pictures of people's penises. Maybe with more, we might know that some crime was committed. Maybe somebody called and threatened her. Maybe the calls were so much that maybe somebody made so many calls that she was harassed. But none of that is part of the statute. And in fact, none of that is part of the facts that the state has improperly offered to this court. So, in 1952, the United States Supreme Court addressed a new technology And the government argued this new technology, this stuff is not covered by the First Amendment. And the U.S. Supreme Court said the basic principles of freedom and speech and the press, like the First Amendment's command, do not vary when a new and different medium for communication appears. That newfangled technology in 1952 was motion pictures. It is beyond cavil now that motion pictures are covered by free speech and by the First Amendment, that the government cannot say you cannot make or display this type or that type of motion picture absent certain very narrow categories, specifically obscenity and child pornography. In the same way, the state cannot say you may not create this sort of web page absent one of those categories. Using somebody's name is not one of those categories. Now, the state argues that this is impersonation. And I always have to look this up to make sure that I have the part of the statute right. But if you look at 33.07a, it does not require that anybody be misled by the communication. But if you look at 33.07b, which is about emails or text messages rather than web pages, it has 33.07b2. It requires the intent to cause a recipient of the communication to reasonably believe that the other person, that is, the complainant, authorized or transmitted the communication. So clearly we can see from 33.07a combined with b that the legislature knows how to write a statute that deals with actual impersonation, that is, where somebody will reasonably be misled by the communication. And we can also see that that's not what the legislature meant in 33.07a. It's not about impersonation, even though that's the title of the statute. The title of the statute is not a guide to interpreting the statute when the words of the statute are clear. And the words of the statute here are clear.
In your brief, you say that this statute is not content neutral because you have to look at the content to see, you have to see what was said to see whether or not there's indicia of intent, I suppose.
You have to look at what was said to see if the name was used or the persona was used. Because if you just see the envelope, if you just see a blurred web page, you can't tell whether the name or persona of the complainant was used. And you also have to look at the content to determine whether there was the intent to harm. Using the state's facts, again, if you looked at if you didn't look at the Craigslist ad to see what was advertised in the Craigslist ad, you couldn't tell whether there was an intent that this poor lady's phone be made to ring or not. And we don't have to endorse the speech to find the statute unconstitutional. Finding the statute unconstitutional, affirming the trial court's judgment with regard to 33.021a, and that's probably what the court should do, is just affirm it in part and leave the other part out, because 33.07b, I would contend is unconstitutional as well. It's just not before the court right now. Let me take out the I would contend. 33.07b is unconstitutional as well. It's just not before the court right now. So that if this court were to sustain, to uphold the trial court's judgment as to 33.07a and reverse it as to 33.07b with the note that we're not saying it's constitutional, it's just not before us right now, that would be the appropriate judgment and the judgment for which we would pray. So the legislature knows how to write an impersonation statute. This is not an impersonation statute. To use somebody's name is speech. It's a communicative act. To post a web page is speech. It's a communicative act. There's no distinction. Flag burning or flag trampling in the Johnson case was speech. Taking a picture in the Thompson case was speech. Yes, Justice Brown.
If we take your position to its logical extreme with other statutes,
yes.
Say, for example, the false statement to obtain credit. A person commits an offense if he intentionally makes a false written statement to obtain credit.
Okay.
Wouldn't that be subject to a constitutional challenge as well, if we take that position?
I would say that that is fraud, just off the top of my head, and
But it doesn't say the word fraud.
Right.
It says if you make a misleading statement in writing to obtain credit, you have committed a crime.
No, I understand it doesn't say fraud, but making a misleading statement to get something of value is fraud.
It doesn't say you're going to get the credit. You're trying to get the credit.
But Making a false statement to try to get something of value is fraud. That's a classical definition of fraud. You don't have to get it to commit the fraud. If I try to sell Mr. Russo the Brooklyn Bridge, it's fraud whether he gives me the money or not. So that would be the answer with that particular statute. I think that there are other statutes that are challengeable, but that's not this Court's concern. The legislature in the last decade has messed some things up with regard to the Internet. The online solicitation of a minor statute where they, in ex parte low, may I finish my thought? Thank you. The online solicitation of a minor statute, they got wrong. When they try to regulate the Internet, the Texas legislature sometimes gets things wrong. That they may have gotten other things wrong is not a reason not to tell them that they got this one wrong. I thank you for your time.
Thank you, Counsel. Rebuttal.
In response to just a few items, the Perry case came up again about threat, and he seemed to imply that maybe that opens up any kind of statute now that may have the word threat in the statute. I don't think that's true at all. Actually, we already have several statutes on the books: terroristic threat, aggravated assault by threat. The specific ruling in Perry had to do with the definition of coercion, and that is the inference I think you can take from the word threat in that instance. I don't think that is a general broadcast of how we're going to treat that word in regular criminal statutes. Secondly, he brought up U.S. v. Stevens, which is a case that I think does help the state, even though U.S. v. Stevens came out in 2010, and it was the Animal Crush video. And the Supreme Court found that it was overbroad because it contained language that let people prosecute people who published animal videos, animal magazines, things that might show something bad happening to an animal. So it wasn't narrowly constructed, and that's why they came down and said this is overbroad. But that's not this statute or Lowe. Both of those talked about the standards is substantial. To go outside to be overbroad, you have to be hitting a substantial amount of speech that would not be allowed. And they still haven't shown why this is compared to Stevens or Lowe or Thompson. In fact, if you run this statute in Westlaw, you know how many hits you get? 0. There's no case law on this statute. The statute has been on the books since 2009. It's not used very often in any sense. There are no claims to show anyone has ever brought this claim and showed that it's incorrect. And if they did...
I'm sorry, and so how is that relevant?
In terms of substantial, to show that it's been charged, that it's used substantially in a way that it shouldn't be. All these other cases that have gone up the courts...
You mean just because the prosecutors have not chosen to file charges against someone under this statute means that the language is not...
It hasn't been
broad?
Challenged, I guess is what I'm saying. I don't think the fact scenario presents itself enough to be overused in this scenario. And if you think about it, if a lot of the claims are about negating the elements of the offense, I didn't intend to threat you, or I didn't intend to cause one of these things, well, we have lots of things for a defendant to bring in terms of cases go to indictment to a grand jury. A grand jury has to find probable cause, right, that all these elements have been met. A person has a right to a trial. A jury has to find these elements beyond a reasonable doubt. And then you have appellate rights. Number one is sufficiency of the evidence. If any of these things is not supported by the evidence, an appellate court has a right to reverse that case on sufficiency and or an as-applied factual challenge. So there's a lot of remedies available to a defendant who makes these complaints, but I think what you see from the wealth of the federal case law from the U.S. Supreme Court and Texas is just because you can imagine a few things that might be questionable, it doesn't mean it's facially unconstitutional. The statute should stand. They have those remedies and available things to them if they want to make that complaint to a court.
And you agree that Section B is not before us at this time?
I agree, and I didn't even notice that, so thank you for catching it. But yes, I agree. I think it's always been that the statute that you are charged under, and if you look back at Ex parte Lowe, Thompson, exact same scenario. In fact, the first court just came down with Ex parte Wheeler in the fall. That looked at the second subsection of 33021 and specifically was to subsection C. So yes, I do think that is the language. I want to point out one other quick thing, just because I think we're having a lot of confusion about, well, this happened on the internet. It's not as bad. It's not as criminal. It's very different than a regular harassing or stalking type charge that you see. An appellate court in Illinois looked at their cyber stalking statute. What's interesting about their statute, it's twofold. It has one that's a physical stalking in terms of following a person, harassing a person, the things that we're used to seeing. It has a second part that's cyber stalking. It's very similar to ours in terms of the intent to defraud someone, to harm someone, to injure, those types of things. And the court was very specific, not only that its conduct, it's the same. So it's not going to be strict scrutiny, it's going to be intermediate scrutiny, but they
But it's not this statute, though.
It is not.
That's
It's very
not-
similar.
Okay, well, I want to ask you about what Mr. Bennett said with regards to whether or not this statute can be content neutral when you have to look at what was said in order to say whether it was violative of the statute.
In terms of the bulk of the statement,
How can you tell that the language that you're charging?
from the face of the document, because we're saying you have the intent to do one of the things that is illegal, I think there's an inference right there. We're not talking about normal statements. We have a scienter requirement, and case law says you can look at the scienter requirement when you're looking at the factual basis of the statement. So we're not just saying you made this comment. We're saying you made it with the intent to harass, alarm, annoy, all those things that are included in the statement.
And so how is that content neutral?
Content neutral in terms of it's combined with the conduct. You have to look at it all. It's a totality of the circumstances. This is not a speech-only statute. Now, if it just had to do with making the statement or making using the person's name in one way, yes. We're saying it's not just that you're making it, you're putting it in a public place and pretending that it's you. And that's the second part of the statute. You have to read it as a whole. And case law says when you have a statement combined with an action, then it is content neutral. You don't get to pretend, oh, because part of it's a statement, it's all First Amendment. And there's cases that say that. Just because there's a statement combined with conduct doesn't mean it's just free speech under the First Amendment.
You're all ready for that. No, I'm good. Okay.
I see that I'm out of time. Do
All
you have
right.
any further questions?
Thank you very much. We appreciate your
Thank you.
briefing and your arguments. You are excused. And as soon as they clear the table, I'm mispronouncing Deputy Guillen's name, Guillen versus Bank, U.S. Bank. Counsel, are y'all both gonna, is he gonna argue?
No, this is my client.
I know, he needs to, I'm sorry for, you need to be back behind the bar.
My apologies, Your Honor.
It's just different for trial court.
Your Honor, I'm ready to proceed with matter of the court.
You can approach.
May it please the court. The court today is faced with yet another situation where a post-foreclosure situation has occurred and the mortgagor homeowner has brought a suit in the district court raising title issues and has asked that the county court on appeal, and this would also apply to the justice courts, are deprived of jurisdiction because the issues of title are so intertwined with issues of possession. This court wrote the Yarborough case, which came out in 2014, and one gets the impression, reading that case, that the court was trying to establish some very clear lines. And the court went through several examples of prior cases and did a rather in-depth analysis of this issue, trying to answer that question: what title questions or issues do intertwine title and possession such that the justice and county courts are deprived, and what title issues don't? For the most part, the court analyzed various title claims or previous cases where various title claims were made and came to the conclusion that they do not intertwine title and possession because of the existence of the tenant at sufferance clause in the deeds of trust, which the foreclosures were based on. In the Yarborough case, however, the court did find an exception to the normal rule that the tenant at sufferance clause provides an independent basis for an award of possession despite a title lawsuit being active in the district court. And that was an allegation that the deed of trust was in fact forged, that the borrower never signed it. This court held that that made the deed of trust void ab initio. Therefore, the tenant at sufferance clause in the deed of trust could not act or be an independent basis for a justice court or a county court to award immediate possession in a statutory action.
There's no fraud here, though, right? There's no fraud in this case, is there?
No.
Okay.
In this case, my client admits he signed the deed of trust, but we have another issue of whether the deed of trust is void, or perhaps more specifically, whether the power of sale contained in the deed of trust is void.
Well, if the power of sale is void, wouldn't that make the deed of trust just voidable, and that would be something that would have to be asserted?
The Supreme Court said in the Holy Cross versus Wolf case that upon the expiration of the 4-year statute of limitations to foreclose, the, quote, lien and the, quote, power of sale become void.
But that doesn't mean that the deed of trust becomes void.
That is correct. In my reply brief, though, I did address that argument, and that was the main argument made in the appellee's brief. The tenant at sufferance clause is contained in Section 22 of the deed of trust in this case. The Section 22 of the deed of trust in this case is the section that governs the power of sale. In fact, it uses the term power of sale several times within that very section. Therefore, if the Supreme Court says the power of sale and the lien are void upon the expiration of limitations, and the tenant at sufferance clause is contained within Section 22, which is the power of sale section, ergo, the tenant at sufferance clause cannot be used as an independent basis because it is dependent on the valid exercise of the power of sale. And if your honors look, and I highlight this in my reply brief, the language of the tenant at sufferance clause, which is at the bottom of Section 22, the power of sale section, it says, if the property is sold pursuant to this Section 22. And this is the absolute key qualifying opening of the tenant at sufferance clause. If the property is sold pursuant to this Section 22. If the property is not, therefore, sold validly under Section 22, the tenant at sufferance clause could not apply. And it's clear that the power of sale, which is what the Supreme Court says becomes void, that the power of sale after the 4 years has expired would not be a valid exercise of the power of sale under Section 22. So the absolute key for this court is the deed of trust may not necessarily completely be void like it was in Yarborough, or like it could have been in Yarborough. But Section 22 is what's void here, because Section 22 governs the power of sale.
But you're, in essence, challenging the validity of the sale.
Absolutely.
All right, well, then what you're asking us to do seems to conflict with our decision in Gardaki, when we said challenges to the validity of the sale do not deprive the justice or county courts of jurisdiction?
It does not conflict, and here's why. Since the subprime mortgage crisis, there's no doubt been a myriad of cases where the homeowners have attempted to save their homes, and they sought to avoid eviction by bringing a title lawsuit in the district court. The typical argument is the assignment was robo-signed and it was void, or they didn't follow the statutory procedures properly to conduct the foreclosure, or it was a wrongful foreclosure, inadequate sale price. No doubt that those title challenges do not intertwine title and possession. This court has been absolutely clear on that. But what's different about this case is the Supreme Court has said the power of sale becomes void. That makes it look more like Yarborough than it does Gardlocki or any of the other myriad of cases where the appellate courts around the state have been saying challenges to the foreclosure do not intertwine title and possession. This is a challenge to the foreclosure, but it's a challenge to the foreclosure because the power of sale had become void, or at least it had been alleged that the power of sale had become void. Therefore, the justice courts and the county courts are deprived of jurisdiction and must abate those cases until the plaintiff at eviction can prove that the statute of limitation claim was lost by a final and non-appealable judgment. And I would point out that from a policy perspective, when a homeowner brings a statute of limitations claim, that they should not be subject to being evicted while they wait to find out whether or not their claim
Didn't bring this claim, or your client didn't bring this statute of limitations defense until after the foreclosure sale had gone through, correct?
That is true, but
And not even at the justice court, I don't think. I think this was part of a plea to the jurisdiction that was filed at the De Novo County Court.
That's right, Your Honor.
So, okay, so statute of limitations is really not a jurisdictional issue. It's an affirmative defense in and of itself that can be waived, right?
There is the non-judicial, the fact that in Texas the creditors can conduct non-judicial sales flip the plaintiff and defendant. The case law is clear.
Well, paragraph 22 says that one of your notices was to give the borrower notice that he could assert any other defense. So it seems like before the sale he would have had a chance. Now he might have had to go down and try to get a TRO, and I don't see in the record that happened either. I guess what I'm concerned about, number one, is the uniqueness of this argument. But rather than jurisdiction because of being intertwined, I might could see jurisdiction because if the tenant by sufferance clause was not active, there's no landlord-tenant relationship established between the parties in this case. And without the landlord-tenant relationship, then maybe the justice court doesn't have jurisdiction.
It's no question an essential element of a forcible detainer action under the statutory procedure is a landlord-tenant relationship. So traditionally, for many decades now, in post-foreclosure eviction actions, the courts have said the bank attorneys or the third-party purchasers who come in have to produce the deed of trust showing a tenant at sufferance clause to satisfy that element of the forcible detainer case. And in this particular instance, the tenant at sufferance clause cannot be relied upon because it is void, but all the justice or the county court has to wait on is the resolution of that statute of limitations claim to be resolved in the court of general jurisdiction, the district court, or in this case, it was removed to federal court. So the landlord-tenant relationship, if the borrower loses his argument that the sale was past the statute of limitations, then the bank or the third-party purchaser goes back to the JP or the county court and says he lost that, so that essentially revives the tenant at sufferance clause, and then they can show a landlord-tenant relationship.
Well, why didn't you go to the district court when you filed your title issue and request a temporary injunction? This would have, it seems that if you're claiming it's intertwined, the better remedy would be, under injunctive relief, it'd be irreparable harm and a probable right to recovery. So if you had those, amongst the other elements, you could go to the district court where you filed your lawsuit and stop this process rather than waiting for it all to take place and come here.
That's a very good question, and the answer is the Texas Supreme Court in McLaughlin versus Kleibert, that's K-L-E-I-B-E-R-T, said that the district courts are deprived of jurisdiction to grant temporary restraining orders until there is a final judgment of eviction, because the court ruled that there is still an adequate remedy at law. So I wasn't able, under binding precedent, to seek a temporary restraining order because the Supreme Court has said my adequate remedy is to seek abatement first at the county court.
Once the county court makes their decision, did you get injunctive relief from the district court once the final judgment took place in county court?
By that point, the case had been removed, and the federal courts have ruled that the Anti-Injunction Act and the Rooker-Feldman Doctrine both apply, so that they have been unwilling to grant injunctions to interfere with state court judgments. So I am unable to get an injunction from a federal court because of these peculiarities of federalism. And that's the Knowles case out of the Fifth Circuit.
Okay, you'll have some time for rebuttal.
May it please the court, Mark Kornowitz for the appellee. We have two main points in our response, Your Honor. The first deals with mootness. The defendant's, Mr. Guillen's, whole argument in this case hinges on the pendency of his suit.
Well, let me ask you a question. If y'all waited over 4 years to get your vendor's lien taken care of, what was the urgency of getting the forcible entry and detainer done in JP court? It seems that y'all had waited all this time to finally take over the property. So
There are different reasons for that, Your Honor. During, as opposing counsel mentioned, there was the foreclosure crisis, during which there were efforts to try to work out loss mitigation programs with the borrowers, which actually was done in this instance, as I'll talk about in a moment. There was transferring of the loans from one servicer to the next, which caused delays from different periods of time. And so there are different factors working at play to kind of like move things out.
but if the 4 years goes by under the statute, is that tenant sufferance clause still valid then? If it's void, as he said?
I don't believe so, Your Honor. I think that 16035 of the Texas Civil Practice and Remedies Code basically says that the lien then is unenforceable, so you can't foreclose. But I don't think that disposes of the entirety of the deed of trust. The note and the deed of trust together form the loan agreement, and so there could be a tendency of sufferance that could be given effect as part of the entire loan document.
Well, it says on the expiration of the 4-year limitations period, the real property lien and power of sale to enforce the real property lien become void, not voidable, just void.
Correct. So as far as like the ability to foreclose, that part of the deed of trust would be unenforceable.
So you can just go after a money judgment?
That's possible, Your Honor, yes.
So are you saying then that the foreclosure was invalid?
Not at all, Your Honor.
All right.
And going back to this mootness point, Mr. Guillen filed an affirmative lawsuit. It was filed initially in the 295th District Court of Harris County. It was removed to the Southern District of Texas, and our client filed a motion for summary judgment in that case One of the main claims dealt with this limitations argument. Mr. Guillen asserted that there was a notice of sale, notice of foreclosure sale provided to him in June of 2010, and therefore the foreclosure sale that took place here in September of 2014, more than 4 years later, violated Section 16035, and therefore the sale was invalid, was void. In our motion for summary judgment, we provided evidence of a loan modification agreement that was entered into subsequent to that 2010 notice of foreclosure sale.
Is any of that in our record?
It is not in your record, Your Honor. It is public record because...
Well, that's okay. Let's talk about something else then.
Okay. Well, that's... I was trying to be responsive to the court's questions, but it kind of gives a little bit of background to the mootness point. So I just wanted to make the court aware that this was litigated to a final judgment. And that final judgment is public record, and we referred the court to that in our appellee's brief. It is published in Lexis. Of course, it's published on the United States District Clerk's website. And that judgment is now on appeal. Now, opposing counsel in this case, Mr. Guillen, take the position that because he has filed an appeal of that final judgment, then we're still in the situation where he's trying to contest title, and therefore the forcible entry and detainer action should have been abated. But that is actually contrary to federal law on the finality and enforceability of judgments. I would refer the court to a case from last year from the United States Supreme Court, Coleman versus Vroman. It's 135 Supreme Court 1759. And that case talks about the finality of judgments in federal court. And to quote from the Court of Appeal, from the U.S. Supreme Court, unless a court issues a stay, a trial court's judgment, say dismissing a case, normally takes effect despite a pending appeal. And a judgment's preclusive effect is generally immediate, notwithstanding any appeal. So the fact that there's been an appeal doesn't make a bit of difference. The separate lawsuit that Mr. Guillen, Officer Guillen, is relying upon for his argument has been finally disposed of. That renders his argument moot. As the U.S. Supreme Court has said here, that judgment is given preclusive effect.
Okay, but under our record that we have, is there any evidence that would support a position that the statute of limitations, as articulated in CPRC 16.035, was violated or passed in this case? That you waited more than 4 years from the accrual of this cause of action? In the record, there's a notice of foreclosure sale from June of 2010, which actually the case law on the running of limitations says that it begins to, that cause of action for foreclosure begins to accrue upon the notice of acceleration. The notice of acceleration is not in the record. But there would be not a notice, I can see that there would not be a notice of sale in the absence of a prior acceleration. Okay. Is that a long way of saying, yeah, it was more than 4 years?
From that first notice of sale, correct.
Okay. And so what happens to, I mean, we've talked a little bit about what your remedies would be, but what do you think are the options for a borrower under paragraph 22 of the deed of trust in a situation like this? How is he supposed to, assuming that you gave notice of his right to bring a court action to assert a defense, I assume you gave that notice, then where's he supposed to go?
He is supposed to file his lawsuit, and he did file his lawsuit. In a post-foreclosure situation, in a pre-foreclosure situation, he could, of course, file his lawsuit and get a temporary restraining order, stopping the foreclosure sale from going forward.
So the case that was filed in the 295th, was that before or after the foreclosure sale?
After. And so in that instance...
Wait, I thought suit was filed March 12th of 2015 and possession was awarded April 13th of 2015.
The foreclosure sale was in September of 14.
Foreclosure sale, right.
That was his suit in Justice Court, I think.
Okay.
post dates.
All right.
The 295th was new to me at argument. I guess
Well-
it's in the briefing somewhere.
And we would ask the court to take judicial notice of that final judgment from the Southern District. We cited it in our appellee's brief, and the court can see that the judgment is out there, and that conclusively supports our position on the mootness argument.
Well, based on the record before us, not talking about what you've just asked us to take judicial notice of, what in the record before us makes the foreclosure valid?
There was not in the record, Your Honor, evidence of the loan modification. But that's consistent with what the FED procedures are set out for. You are not supposed to, you cannot litigate title in an FED proceeding. It's limited. And
But excuse me, I think this is the deed of trust that you submitted to the county court that came up in our record. You didn't submit a loan modification deed of trust. It was this one, I believe.
that's right. And the loan modification did not change those material provisions of the deed of trust, which established the lien, established the tendency of sufferance, and those are the key reasons why.
So you say, but if it's not in our record, why are you wanting us to take judicial notice of what you just said?
I'm asking the court to take judicial notice of the final disposition of his second lawsuit, which is what he needs, he's depending upon to support his argument that the FED should have been abated. And because that second lawsuit was decided against him in a final judgment that is to be given preclusive effect, as the U.S. Supreme Court says, then this whole appeal is moot. Have I answered the court's question?
Not really, but go ahead.
I'm sorry, Your Honor.
Just keep-
And I will say, we did not present the loan modification agreement in the trial court because FED proceedings are not where you're supposed to do that. And Yarborough talks about that in the forgery context, when a defendant, the property owner, wants to make the argument that the FED should be abated, then that defense needs to be raised and some evidence presented in support of it. And that's kind of where it stops.
Okay, so what evidence did you have of a landlord-tenant relationship at the FED hearing if all you submitted was what you're telling me was a superseded deed of trust?
The loan modification did not supersede the deed of trust. All it did was adjust the payments, allowing the borrower to make additional payments. A loan modification agreement does not materially alter the original terms of the deed of trust.
Oh, but I was assuming, or I was hearing you to say that having a loan modification somehow made the cause of action accrue at a later date, and so that the 4 years was not an issue anymore.
That is true, and that is what Judge Gray Miller decided in his final judgment. Because when a loan modification agreement is entered into, after a notice of acceleration has been provided, it is allowing the borrower then to make payments again. And there's a whole bunch of case law on this point, and Judge Miller cites to some of that in his opinion, that
Well, lucky for him, he had some different evidence than we have with us. So I don't know what good it's going to do us really to look at his opinion if he was looking at different evidence.
well, the court is kind of asking some questions about that case, and so I'm trying to be responsive to that. But as far as this FED appeal, all that matters is that Judge Gray issued a final judgment.
Right. Now, I wasn't
Against-
asking about that case. I was asking about the evidence in this case, which I'm not quite understanding what you want me to believe the evidence is that's different from what we have in our record.
I'm not asking the court to believe that evidence is any different. I'm just arguing to the court that none of that matters. None of that matters as far as the loan modification, as far as what the trial court could do in this instance. So,
Do you remember what page of your brief the mootness argument is argued?
it's at the end, Your Honor?
At the end. Okay, thanks. I'll find it.
Okay. All right, then I'll go on to our alternative argument, which is that if the court should find that the appeal is not moot. Now, Mr. Guillen's counsel in his argument talked about Yarborough and talked about the tendency at sufferance. And Yarborough talks about the cases when a title dispute might actually support a trial court's abating an FED case. And it is in those instances where title has to be determined as part of the resolution of the FED. But as Judge Brown was indicating, when there is a tendency at sufferance and you're talking about procedures, then those issues as far as whether the procedures were met during a foreclosure sale, those can be litigated in a separate suit while the FED goes forward. Yarborough is directly on point on that position. Now, in Yarborough, it was different than the usual situation because of the forgery allegation. Under the case law, if a document has been forged, then like a deed, then no title passes, no rights are conveyed. And so when you're talking about the tendency of sufferance clause in the deed of trust, if that deed of trust was forged, then the tendency of sufferance would not give rise. But we don't have that here. Well, all we have is the argument of limitations, and the court raised this issue with opposing counsel's argument about what kind of effect does limitations have. And there actually is an opinion from this court from 2010 that addressed the issue. And it's the Modellist versus Deutsche Bank opinion, number 1409-134-CV. And in that opinion, the property owner defendant asserted this argument that more than 4 years had passed from the accrual of the foreclosure cause of action. And because of that, his foreclosure was void. And this court said, it says, Modellist, who's the property owner, also challenges the county court's subject matter jurisdiction by presenting a statute of limitations argument. However, the gist of his argument is primarily that the foreclosure sale was barred by limitations. Therefore, this contention is encompassed with any separate title dispute pending in district court. It is not a basis for opposing the forcible detainer action. So, just like the other cases, as this court referred to in Yarborough about improper foreclosure sales, or the Murray court talking about a release of the deed of trust, all those cases talk about defects in the foreclosure procedure, which could be raised in a separate action and do not provide a basis for abating the FED. I see that my time is up.
All right.
Thank you, Your Honor.
Thank you so much. Rebuttal.
Your Honors, there was a lot of discussion about the title issues that are currently before the Fifth Circuit Court of Appeals. I would just like to make absolutely clear those issues have nothing to do with this court's decision in this case. This is an appeal from a statutory forcible entry and detainer case. I filed my appellant's brief in the Fifth Circuit actually yesterday, and I will represent to the court that I have several good arguments as to why the loan modification is ineffective. But that's not before this court. That's a title issue that's not before this court and wasn't before the county court. So anything, the fact that Judge Gray Miller over at the Federal District Courthouse granted the bank's summary judgment is irrelevant, completely irrelevant to these proceedings. I would also like to point out, with regard to what I was getting at earlier, with non-judicial sale, the borrower has to become the plaintiff, and it's up to the plaintiff to bring a declaratory judgment or quiet title action to remove the void lien or void deed of trust. And there's a recent case coming out of Waco that makes that clear, EMC Mortgage Corporation versus Window Box Association, 264 Southwest 3rd, 331, and that's cited in my appellant's brief as well when I discuss generally my title lawsuit and how my title lawsuit adequately alleged a violation of the statute of limitations and requested the correct relief. Also, Your Honor, with your honors, excuse me, with regard to the Modellist case, he said that the 14th Court in 2010 came out with this case. It was a memorandum opinion. It did, as an afterthought, lump his statute of limitations claim in with the other claims. But this case came before Yarborough, and it doesn't appear from the record at all that the homeowner or the homeowner's lawyer in that case argued the Wolf case. So now that the court has the benefit now of the Wolf case, knowing that the lien becomes void and the power of sale becomes void, and it also has the benefit of the Yarborough case where you found the deed of trust was void, you are free and clear to essentially overrule the Modilis Memorandum case and conduct the correct analysis with the adequate briefing you've received in this case with regard to the Wolf versus Holy Cross and the Yarborough case. And finally, I would like to point out that his federal case law, where he says the judgment has become final, I don't quite understand his argument, and I'm not sure the court does either. How can a case on appeal be final? The fact is, this is not a moot situation. They could get a writ and come and evict him at any moment. The title issues have yet to be finally decided. It's on appeal to the Fifth Circuit right now, so the case is not moot. And that concludes my argument.
All right, thank you so much for your briefing and your arguments. This case is submitted, and we're adjourned.